Hi everyone, my name is Bridget and my partner here is Carl, and we're both members from the AGIS, and we're really grateful for all the members of the panelists that took time out of their busy schedule to be here today. The reason why we came up with this program was to kind of give students and also aspiring barristers a little bit of opportunity to gain a little insight into different areas of law. So about a week ago, we did the same thing with family law, and today we're doing criminal law. If you have any questions for the members of the panel, please drop in your questions in the Q&A session. And just to start with a little bit of introduction, I'd like to ask each member of the panel to give us a little bit of introduction of themselves, their names, their chambers, and their criminal area, whether defending or prosecuting. So if we can start with Joel.
Hello, good evening. Yes, this is embarrassing. I was called in 1985, and I'm acutely conscious that I doubt anyone listening or watching was even born then, but there we are. I started off in what was then Tooks Court, Tooks Chambers, which was Michael Mansfield's chambers, which was essentially a criminal defence set, and that's what I did. 7 years ago, I moved to Doughty Street Chambers, where I still am. My basic practice is either defending at trial level in the Crown Court or appeal work in the Court of Appeal Criminal Division. I do some other stuff around the edges that has its roots in criminal law, extradition, defending solicitors from their professional allegations of professional misconduct for solicitors disciplinary tribunal. And that's about it, really. I've only ever defended in court work. I've prosecuted barristers to the Bar Standards Board. It's another story, really, and that's what I do.
Thank you, Joel. Oliver, do you have the same area as well?
Good evening, everyone. Thank you first to Nikki, Bridget and Carl for having me this evening. I'm a barrister at 3 Temple Gardens. That's where I completed my pupillage and where I was taken on as a tenant earlier this year. Yes, to answer your question, Bridget, I mainly defend, probably about 95% at this stage in my career, but I am a grade 1 prosecutor. My chambers only prosecutes in the Crown Court, so I don't have any, although I defend in the Magistrates Court and the Crown Court, I only prosecute occasional cases in the Crown Court. Like Joel, I also do some related areas, mainly extradition for me. In fact, that's what I'm doing tomorrow, so I have an extradition hearing tomorrow. I originally, my background is in, did a history degree originally, then did the GDL and then the Bar Course, and then was called by Gray's Inn in 2018. So mine is quite a recent perspective and hopefully therefore can shed some light on what it's like and hopefully reassure people as well that it's possible.
Thank you, Oliver. Laurie?
Hi everyone, good evening. My name's Laurie Patterson. I'm a barrister at 30 Park Place in Cardiff. I was 2017 call and I did my pupillage from September 2018 to September 2019. So I've been a tenant now for just over a year. At 30 Park Place in Cardiff, as is quite typical of a lot of the Welsh chambers, I have a mixed practice. So at the moment, I know this is a criminal talk, but criminal makes up about 40% of my work. The other 40% is family and then 20% civil. In terms of the criminal work that I do, it is mostly prosecuting in the Magistrates Court and the Crown Court. So as Oliver was saying, he doesn't really prosecute in the Magistrates Court. When I was a pupil, especially up until relatively recently, I was prosecuting a lot of Magistrates Court lists. Now I've sort of moved on a bit from that, so it's mostly Crown Court, but every now and again you might see me in the Magistrates Court.
Thank you, Laurie. I would like to hear from you, Laurie, in terms of your journey to the bar. Why did you decide to pursue criminal law in particular? Was there any determining factor? And in terms of pupillage, what was your experience in applying for pupillage, and what advice would you give to someone applying for pupillage now?
Okay, so taking the first part of that question, why criminal law? So when everyone is in school and everyone's thinking about a career, when you think of a career as a barrister or in the law, the first thing that comes to mind is the criminal bar. You then start university and you realise that there is a lot more to it. Criminal law is just a tiny part of this really wide spectrum. One thing I realised once I sort of got to the vocational stage, so when I was on the BPTC, my advocacy skills and my advocacy marks were probably higher than my drafting, and it was something that I enjoyed a lot more rather than sort of the written-based drafting side of things. And it just so happened that most of the advocacy modules are tied into criminal law in some way. When advocacy is something that you enjoy, you are inevitably going to lean towards criminal law because they have the most advocacy. That's the reason you sort of join this career. And someone asked me when I was a pupil, oh, have you had that barrister moment yet? And the answer is yes. And it was when I was cross-examining in a trial in the magistrates court. If you enjoy advocacy, then you will naturally then enjoy doing criminal law. So that's how I ended up doing it. But of course, I have a mixed practice, so I am able to supplement my practice with other work. In terms of my pupillage and how I sort of came to be at 30 Park Place, I did my pupillage at BPP in London. I was applying for pupillage while I was on the BPTC. I was also applying for paralegal jobs at the same time. This is something I really wanted to touch on because it's something that people don't very often talk about, and that is paralegal jobs. Most people at the bar will have been a paralegal at some point. I was a paralegal for a year, my co-pupil was a paralegal. You look at people around about our area of call and it's very, very common. Because of the way pupillage works, and it is so far in advance, I knew that statistically, you're not looking very good at your chances of getting pupillage. Even if I did get pupillage, I would still have a year where I needed to do something. So that year when I was doing my BPTC, I was sending off a lot of applications, not just for pupillage, but also for paralegal jobs. So I was a paralegal for a year at NHS Wales Legal and Risk Services. So that was just clinical negligence defendant work, very different to crime, but a lot of people come to this career from all sorts of angles. So that's sort of how I ended up then at 30 Park Place in Cardiff. I am Welsh, I always had an interest in coming back to Wales and pursuing a career here. So that's how I ended up where I am. I hope that's answered all of your questions, Bridget. I can't remember
thank you so much.
What else you'd asked, but
thank you.
That's my experience.
Thank you. I would like to hear from you, Joel. Did you have a similar experience, or do you have a different reason why you decided to pursue criminal law in particular?
I think I always wanted to defend in criminal cases because, as Lowry said, that's the stuff you see on the telly. That's the stuff that catches your imagination you read about. Again, so I'm sorry to be plunging back into stuff that some of you will study as history at school. When I was starting out, it was the miners' strike was only just finishing, and that was in terms of lawyers, criminal lawyers, and especially left-wing criminal lawyers, because I was coming from that political background. We all wanted to work defending. I was just too young for the Battle of Orgreave trial, but big trials about that sort of stuff. So I went to a chambers that was the sort of loony left in those days. It was certainly seen as that, with some justification, I suppose. And that was the political background I came from. So it was a natural place for me to go. Thank God I got in, so I'm not sure I would have been accepted many other places. And I just carried on defending in crime. Sorry, what was the other bits of the question?
It was in terms of pupillage. Did you have,
Pupillage.
What was your experience, yes, in applying?
Yeah, pupillage was fine, but the systems moved on a bit. We didn't have computers unless you were flying to the moon then. Yes, no, my first 6 months pupillage was with a barrister called Adrian Fulford, who's now the Vice President of the Court of Appeal Criminal Division, Tooks Court. My second 6 was with Owen Davis, now he's Honour Judge Owen Davis, QC retired, who was at Garden Court, the other, in those days, big lefty chambers. It was fun. I mean, first 6, obviously a very different experience. I spent a great deal of time. I think you tend to be closer to your first 6 pupil, master or mistress, because you spend time with them. The second one, if you're lucky, you're busy. And I really enjoyed crime. And it does, again, to touch on something Lowry said, because you're doing so much advocacy, I do think, I would say this, wouldn't I, that criminal barristers, the criminal law produces the most confident advocates. And people quite often do move into other fields. I mean, Oliver was talking about extradition. I do a bit of that. And when we arrive in the new field, there will often be a lot of non-criminal lawyers there who may, you know, be expert in certain things, but we tend to have the edge just because we're used to cross-examining, making speeches, arguing, because of the big oral tradition. That's not to say other people don't do it very well as well, but we just have the flying hours. So that's something I've enjoyed, and with a bit of variation, much more appeals these days. That's what I've been doing ever since.
Thank you, Joe. In terms of given that it has really changed given over the years, what advice would you have to someone applying now to become a criminal barrister in terms of pupillage?
I mean, basic advice applying for any job, approaching any test, prepare carefully, look at the questions you're being asked. I mean, I've sat on pupillage interviews a couple of years ago at Doughty Street and quite a lot at Tooks 10 years ago. Look at the question you're being asked. You'd be surprised how many people are there. They're on the paper good candidates and they have to answer a certain question and they talk about something else. So think about what you're being asked. Preparation always helps, and persistence is the other thing. Again, it's changed a lot, but I still think that's an underrated quality, possibly in life and certainly at the bar. I mean, we had, again, a long time ago now, we had two pupils. We took them both on. One was a golden boy from Oxford or Cambridge, had a first. We were amazed he applied to us at all, really. And the other one just scraped through. And 3 years later, the posh boy was a trainee aromatherapist, giving it all up, and the other guy kept plugging away, and you know, built a successful career at the bar. So keep going, and don't be put off by, you know, of course the odds of. I was told stories when I was doing my dinners about just how hard it was to get a pupillage, and you'll be told the same stories now in you know, framed differently. But in the end, if it's something you want to do, keep plugging away.
Thank you, Joe. Oliver, do you have a similar experience, or do you have a different view about this?
It is very similar, really. I was quite fortunate when I applied for pupillage. It was during my GDL year, and I was fortunate to get pupillage the first time I applied, which was quite rare for my colleagues at the criminal bar. Both of my co-pupils, I think, got pupillage on their third attempt, but they're no lesser barristers for it. And in fact, actually, the 3 years during which time between their calls to the bar, both in 2015 and between starting pupillage in 2018, they used that time to do, as Lowry said, they were both paralegals and built up not only contacts with solicitors, but also a wealth of knowledge and experience, which they brought to bear very successfully during their early careers at the bar. So in some ways, it's been a bit of a catching up process for me, because I came in very fresh-faced. As a 2018, I was called to the bar. 2018, I began my first six. As Joel says, I'm still very close to my first six supervisor, and the way that my chambers does it is we have a new supervisor every 4 months. So my first 4 months were with one supervisor, and then I moved to another for the final 2 months of my first six. And then, so I had built a relationship with him for when I started on my feet in my second six. And I found that a very good system, because it meant that I had that established relationship rather than starting afresh with somebody in second six who I didn't really know. And indeed, my chambers does basically an automatic 18-month pupillage. We set out at the beginning with the full knowledge that we're not going to have the opportunity to apply for tenancy after 12 months. Effectively, that comes at the 18-month stage. And that is increasingly common at the criminal bar especially. And actually, although it is quite a long slog as a result, and you know, pupillage paranoia, as people call it, is a very real thing, because it's like a very long job interview almost for that application for tenancy. But at the same time, that third 6 months in particular was very helpful to me in building, because by that point you have a full practicing certificate after your 12 months, and you're gradually building a practice, building relationships with solicitors, finding your feet quite literally. in court. And as a result, that final 6 months of my pupillage was very helpful when it came to applying for tenancy, because I'd just built up better relationships with people around me, and indeed with my clerks, who obviously have to support the application that you make for tenancy. So for me, pupillage was a difficult process. Of course it was very hard work. I won't make any bones about it. It is a tricky time, but it is hugely enjoyable, and I have never been on a learning curve like it. It's incredible. The first week that you do on your feet in Second Six is the steepest learning curve that you could possibly imagine, but so exciting. And as both Larry and Joel have said, it's very much a case of, if the criminal bar is for you, it's probably because you enjoy oral advocacy. And that was certainly the case for me. I loved it from the outset, and hence why being on my feet was just hugely exciting. I think that answers hopefully the question as to what it was like, my pupillage experience.
Yeah, thank you. Oliver, there's a usual question that we are all being faced with. Usually, if you're tending to do a lot of application, is why the criminal bar, in terms of why did you choose it? So people think in terms you have to be kind of honest, but at the same time you need to avoid giving like cliche answers like, oh, so how do you think is the best way to answer that question? Like, do you really be honest, or just try to say, oh, because I do enjoy advocacy and all that? Because I feel like they do want to get a sense of who you are, so what do you think about that?
It is a very difficult thing to do. That pupillage form, for me, it was a real labour of love, and really that's my abiding memory of applying for pupillage, is spending hour after hour after hour making sure that my pupillage form, my pupillage application form, was how can I make it tighter? How can I make it less verbose? How could I make it more persuasive? And you're right, that question of why the criminal bar, or indeed why the bar, is a difficult one to answer. But if you've got to the stage of applying for pupillage, you will have an answer. There will be a reason why you're applying to the bar, and in particular why you're applying for the criminal bar. Life at the criminal bar, I'm sure we will mention this later on, is not going to be a life of luxury and millions. Crime really doesn't pay when it comes to the bar, and as a result, it's very likely that you will have a very specific reason why you want to do it. For me, it very much was, number one, oral advocacy. Number two, very much the human aspect of it, because although I found certain aspects of the academic civil law very interesting, I didn't really foresee a life of persuading people to give up this certain amount of costs or this financial settlement or whatever it may be. Really, it's the human drama of the criminal bar is hugely attractive to me, because you meet a huge range of fascinating people, and you see things which happen across a vast emotional spectrum. When your client's convicted, it can be heartbreaking. When they're acquitted, it can be the best feeling. You can walk out of there feeling lighter than air. So it's, for me, that was very much the reason, or rather the reasons. And I think if you've got to the stage of applying for pupillage at the criminal bar, then certainly you will have a reason. And you're quite right. I think honesty, it really is the best policy, unless that reason is somehow bizarre or entirely odd. Then maybe it might be a question of rethinking rather than trying to fudge your application. But that application process, it's like the question, why this chambers? It is very difficult for a lot of people, unless you've done a mini pupillage there, in which case you can rave about how brilliant the barrister who you followed around was. It can be a really difficult question to answer, because you don't want to just be reflecting back the website of that chambers. They know what's on their website. So it can be a tricky question to answer. But again, honesty is usually the best policy. And just on that point, I wanted to touch on this actually, is realistically, when you're applying for pupillage, the work that you're aspiring to do at that set will be the work that is being done by the barristers in the first 10 years or so of call. There may be some brilliantly experienced barristers, Joel, for example, who might be doing fascinating things, and will be no doubt, I mean, we have a QC in our chambers who I think has done various sort of art cases, art law cases and that sort of thing. Realistically, you're not going to be doing that within the first 10 years of any practice that you do, or indeed during your pupillage. The cases you might be covering for people are going to be those of the first 10 years of people's practice generally. So be realistic about the work that you're aspiring to do, because that is the bread and butter, that's the meat and drink of that chamber's work. And I think that's crucial to reflect back to them in that form. Don't be saying, oh, there's this fascinating, this QC did this one case in the Court of Appeal and I found it fascinating. Realistically, you're not aspiring towards that at this stage in your career. You're more experienced, going towards the, I've seen X, Y, or Z do a defend or make a bail application on a Saturday morning at Westminster Mags, and I found his approach brilliant. I was really interested by what he said and the way he approached it. I spoke to him afterwards, something like that, something slightly more personal. And I think realistically that's the key to it, is showing a level of personality, being honest, whilst also making sure that you're being as persuasive as possible.
Thank you, Oliver. We'd like to hear from every member of the panel regarding your day-to-day practice. Kyle is going to ask some little bit of questions in regards to that.
Thank you, Bridget, and good evening, everyone. Thank you all for being here. So, Oliver, perhaps if I can start with you while we've already got you rolling. As one of the more junior members of the bar, what is a typical working week for someone in your position?
Well, what I'll do, and I think the easiest way for me to answer this, is give you my working week this week. So yesterday, I had my first hearing was a bail application via CVP. So CVP is the cloud video platform. Lots of criminal cases during COVID have been conducted in this way, especially where the defendant isn't required. This was an application to the Crown Court for bail for somebody who'd had bail refused in the Magistrates' Court. I dealt with that via CVP, finished at 10:30 and received a call from my clerk 7 minutes later saying, are you at Southwark Crown Court? I said, no, I'm at home because I've just done this via CVP. I thought you were at Southwark. Well, that's because my case was listed at Southwark. And so then I had a mad dash to Southwark Crown Court to represent somebody at a PTPH. Then the van didn't bring my client for that PTPH, and so the case was subsequently adjourned. Then I went home, and at about 3:15, got a call saying, can you get to Snaresbrook Crown Court? And so I started making my way there before I was stood down because the case had been adjourned. Welcome to the criminal bar. Today it was Bromley Youth Court for two matters. One was the third day, and actually for the conclusion of a trial that I've been doing in front of one of the district judges there. Quite a serious matter, but for a young person. And the other was for a first appearance for another youth who was only 15. And that was that. Got home, and at 2:50 this time received a call, could I get to Ealing Magistrates Court? Again set off, again stood down. This is a recurring theme, but it often happens, especially at this time, because the criminal courts are just so busy, especially after COVID, because lots of the stuff that's been adjourned during the COVID pandemic is now coming into lists. So they are dealing with lots of non-urgent cases that were adjourned during the COVID months. Tomorrow I have a final hearing in extradition in the morning, but may well be sent somewhere else in the afternoon, I don't know yet. Thursday, at the moment in my diary, is a PTPH at 12 and a Magistrates Court trial defending at 2 p.m. Those courts are fortunately only 45 minutes apart from each other, so I should be able to make it between the two. And then on Friday, at the moment in my diary, though I'm not sure if I will be actually doing it, is a Magistrates Court trial, but at Swansea Magistrates Court of all places. So I may be on the 5:23 out of Paddington to get down there for 9 o'clock. So I may well be coming down to Lowry's neck of the woods. So that's my current working week. As you can see, a mix of magistrates, youth and Crown Court. And at my stage, I'm starting to get more and more Crown Court work because I'm now a tenant. but I'm still frequenting the Magistrates Court and Youth Courts. For me in particular, I do quite a lot of youth work. It may be because I'm young, but also it's because I have quite a detailed interest at the moment in cases involving victims of modern day slavery. Developed that interest throughout my pupillage, and unfortunately, very frequently, young people often involved in county lines type offending are often deemed to be at least victims of modern slavery in some way, or certainly being exploited in some way. And as a result, regrettably, it forms quite a significant chunk of my practice doing youth court work that relates to that.
Thank you very much. Lowry, I assume it's something similar again at your end of the bar?
It is very similar, but the difference I have is having a mixed practice. So every single week is completely different, and I really truly mean that. So 2 weeks ago, I was doing a week-long non-accidental injury case in care for a local authority. Next week, I have a 2-day jury trial defending in Merthyr Crown. Then I have some private law family on Wednesday, and then I have a 2-day final hearing in family public law then on Thursday and Friday. That's quite sort of standard, that sort of mix. But one thing that you definitely get from somewhere like 30 Park Place, where I am, is you could be asked to do absolutely anything, and especially when you are this junior. It hasn't happened so much over COVID because during lockdown they've been concentrating on getting the family care cases through the court and getting things through the Crown Court. But you can be asked to do all sorts of weird and wonderful things. So whether that could be a bit of housing, a bit of immigration. My second six pupil supervisor had a really mismatched practice. So now every now and again I pick up work because I'm marketed as his former pupil. So it is very different. A lot like all of us said, you are flying by the seat of your pants a lot of the time. On a slightly different note, I very often get calls at about 3 o'clock, 4 o'clock on a Friday. Can you do an interim care order? This seems to be the recurring theme in my practice because I do family as well. The difference being with that is family is still, or at least in South Wales, it's pretty much entirely by CVP. There's just too many people to get in a room in family law. Crime, however, is business as usual, or at least it certainly is in South East Wales. Cardiff, Newport and Merthyr are nearly at full capacity. I've never seen it like that. When I started on my feet in March 2019, they didn't have every Crown Court sitting in Cardiff. And I went into Cardiff Crown Court 2 weeks ago, and on a Friday, which is the busiest day of the week, and I had genuinely never seen it that busy. And I don't mean that as in post-COVID, as in genuinely, I have never seen that many people in Cardiff Roping Room. So they are getting a lot of things through the Crown Courts. So it is busy, but I suppose the difference to all of us is while you are travelling between courts multiple times a day, in family it's great because you're by CVP. So I was in Swansea at 9 AM, Bristol at 11:30, and then back in Swansea. You couldn't have done that in person. In the Crown Courts, even in South Wales, most of my Crown Court work is South East Wales, which is Newport, Cardiff and Merthyr. So they are all relatively close together. You have to be able to drive in South Wales. You couldn't have done that on public transport. It just wouldn't be possible. You might have to go to Swansea. But I suppose that's the main difference, is everything is slightly, not geographically closer together, but more accessible. So that's sort of my average week. It is really varied, and I do mean it is very, very varied.
And as someone with such a mixed practice, how important is your relationship with your clerks, with being so available and being able to put your fingers in so many pies, as it were?
It's so important, especially at times like this when everybody is so busy. You know, like I was saying, the Crown Courts are really busy. They are trying to get so much through. The family courts are the same. So the relationship with the clerks is obviously very, very important. And it's funny, you get marketed as being so-and-so's pupil or so-and-so's pupil when you haven't done a case for that solicitor before. That's sort of your stamp of approval. But the difference that I've seen recently, it's something I wanted to touch on post-COVID. So my practice, as I said earlier, is probably 40 crime, 40 family, 20 civil. From January to March of this year, my work was 50% civil, 30% family, and 20% crime. So almost straight away from when we went into lockdown, my practice areas changed completely. It was stuff that I was already doing, but it's funny how when you are so junior, you just go where the demand is, and there is that massive demand in criminal work, and there was that demand in family work. I will have to specialise eventually. I can't keep doing everything like I am at the moment, as much as I would love to. But one thing that I think everyone has realised during COVID is you have to keep your options open. I always say that to people when I'm at pupillage fairs. When you're at somewhere like 30 Park Place, you could do a really interesting inquest for somebody and then realise, oh, that's something I would really like to do. So keep your options open. Well, never more so than now. Because I was so junior, I just went where that demand was. And I've never been so grateful to have such a flexible practice that has meant I've fortunately been very, very busy throughout the lockdown period. So yeah, do keep your options open, and your practice could develop in a number of ways, really.
Thank you. Joel, perhaps if I could turn to you, as somebody that is obviously at the much more senior end of the bar, what's your typical working week look like?
I mean, this year's been weird for all sorts of reasons. This year's been an awful lot of appeals, which I do a lot of, looking at sets of papers, which in the old days would have been 50 Libre Arch files, but now it's all on a pen drive or on Dropbox or whatever. The great advance this year actually has been video link conferences to prisons. I mean, I had a couple of hours with a guy who's got a murder trial, but he'll be on trial for murder next year, in Hewell, you know, so up near Birmingham, out near Birmingham. Well, if I was seeing him in real life, I'd have been up at 5 o'clock. I'd have got back about now. As it was, I was up at 7, so I wanted to do half an hour's work after I, got ready, go on the computer, there he is, and we chat for a couple of hours, and then I'm home. So that's a great leap forward. I'd like to keep that. Normal years, which may return in a few months, I would tend to be doing quite long trials, which would tend to be terrorism. I did lots and lots of for certain reasons. Murder trials or fraud trials. I spent most of last year doing linked fraud trials. It was all one case, but it had been chopped into different trials. I mean, I feel completely exhausted listening to Oliver and Lowry's days. God help me. I would tend to get to court. I mean, let's say the fraud trial, Southwark Crown Court. I would get there early because I like to work in mornings. I get there about 8:30. You have the luxury of a room in that Crown Court, which you can lock every night. So my robes are there, my papers are there, and I work for an hour. The client will turn up. I'll chat to him for half an hour. I'll talk to the junior, the rest of the team for half an hour. Then we'll be in court. And the thing about a fraud trial, I had a friend once who did the this story leads somewhere. Hear me out. Did the Trans-Siberian Railway, and they said it's such an endless tundra that people get really excited and say, oh, there's a tree coming up. Fraud trials are a bit like that. You think, oh, I may have to cross-examine a witness tomorrow. Oliver and Lowry would be cross-examining a witness at 3 o'clock that they didn't know existed at 1:30. I'll have days to think about it. So it's quite nice. It's quite a leisurely way of life. It's much better paid, obviously, than when you're starting out. So that my normal day is go to court bright and early, come home pretty soon when the court rises, 4:30. On a good week, I'm not working in the evenings, so I'm getting in a couple of hours before the court day starts. On a bad week, I may be in the Court of Appeal one morning, so I've got to get ready for the appeal while the trial's also rumbling on. That's how I tend to be working in normal times.
So on normal times, I suppose, the courts have had to make quite significant changes through the coronavirus pandemic, especially with things like the crowd video platform. Do you see those as changes that are here to stay, or do you think we'll return back to normality at some point?
I think there's two aspects. I think actual trials will get back to normality, and they are starting. I mean, Lowry and South Wales is miles ahead of us. The Bailey's got, I think, 4 or 5 courts sitting because they use another courtroom, as the jury retirement room in some of those buildings. So that will, God willing, vaccine willing, that will change and we will go back to normal. I mean, I hope to God video link conferences stay. I will still now and then want to go and sit down with a client, and, you know, going back to something Oliver said, that for me is always quite an important reason I do the thing I do, which is I do like the time of meeting someone, often in very desperate straits, and you talk to them and you know, maybe tease them and try and get them to come out themselves. So I like all that. So I will still now and then sit down in the same room as my client. But if I have to see a client, I don't know, 4 times in conference before a murder trial starts, if I can do 3 of them from this here table, I would love that, you know. I'll just stay here, and when I finish, we all wave goodbye at the end, which you don't do in real life in a Belmarsh prison or whatever. And I'll go and put the kettle on, I'm home. So I'd love that to stay.
Thank you, Joel. Oliver, do you have a similar view, or?
I'm hugely hopeful that CVP will hang around for certainly those cases where the defendant is not required to attend, or where they are required to attend but not to, for example, enter a plea or for instructions to be taken. So mention hearings in the Crown Court or case management hearings in the Magistrates Court. It would be hugely beneficial, in my view, if that kept going, because it does mean, as Larry says, you can be in 3 different courts in a morning without leaving your front room, which does seem to make sense, because, you know, at the junior bar in London, we are travelling all the time. If you're claustrophobic and you don't like the tube, criminal bar is probably not for you in London. It is a constant travelling job, really. It's very peripatetic in that way. And so if that could stay, that would be hugely beneficial. I mean, the court's response generally to the COVID pandemic has been, in my view, quite slow and not particularly, not very good, basically. But there have been some benefits, like the cloud video platform, I think has been really good. And it is quite a good video platform as well, so far as I can see. And as Joel said, you know, I've been having conferences with clients in Wormwood Scrubs, for instance, where I can dial into their video link facilities from my laptop, and that is revolutionary, really. But the Magistrates Court, I was going to court throughout the pandemic because there were overnight remand hearings from the outset, which I was still going to do because you couldn't do them all via CVP or via telephone. And it was a strange old world initially, because obviously I was going out during that first lockdown when there was nobody about. And also as it gradually started back up and the court started back up in sort of late May, early June time, there were, you know, it felt a little bit dangerous, frankly, because you've got clients coming from prisons where it could potentially be a hotbed of COVID and you just don't know. You had people, before the kind of masks became mandatory, people just walking around and speaking far too close to you and not observing social distancing. And in my local court, regrettably, one of the cell staff actually passed away from COVID-19. So it was a bit of a scary time. And you sort of did feel a bit like maybe the courts aren't doing enough to protect the court users. But gradually it's become better, and masks are being worn in the public areas. The way that jurors are sitting with perspex screens between them and that sort of thing, it's gradually getting there, but the response was quite slow. So the criminal courts, unfortunately, chronically underfunded, and as a result, weren't going to be the best, practically speaking, at adapting to the situation. But we're gradually seeing some quite good improvements, and some things that I really hope will hang around, like CVP.
Thank you. So it's just sort of on that, whilst as COVID pushes through, then how do you see sort of your own criminal practice developing over the next sort of 5 years or so? Well, for me, the first aim when you become a tenant is to try and gradually get yourself out of Magistrates Court work and into more and more Crown Court work, such that you build a Crown Court practice. Realistically, in my first 5 to 10 years, that's going to be
you know, either way offences of lesser seriousness, which end up being tried in the Crown Court. I think because of the backlog that is now existing in the Crown Courts, which is approximately 50,000 cases awaiting trial or so, there is going to be a lot of work out there for barristers, which in some ways is great. It will be very busy, and I'm sure there will be all sorts of problems with that as they try and wrestle with that backlog. But I see an opportunity, because I'm a hopeless optimist, I guess. I've got now, I think, at least 3 or 4 cases have been put in warned lists for sort of summer of next year in the last 3 or 4 weeks. So when I've been doing various PTPHs, they've gone into warned lists in August. I've got one fixture in February. So gradually, these Crown Court trials are starting to come in for me, and hopefully they're effective and I can get underway with some of those.
Thank you. So Laurie, on to your, again, as we've spoken about, you've got a varied practice. How do you see your own practice? How do you intend to go about sort of, not necessarily streamlining your process, but in deciding where you're going to specialise?
I think that decision is going to be made for me. If you are good at something, you tend to get instructed in that area a bit more. It's quite a diplomatic answer. I've tried not to specialise. I've only been a tenant for a year. Because of COVID, I'm probably going to delay specialising maybe a bit more. But as Oliver said, it's something that I really see happening for the next year or so, is just I see myself doing a lot more jury trials. Obviously, I'm coming through with the same sort of level, moving on from magistrates court work towards doing more Crown Court work. And I've just come to terms with the fact now that in the not so distant future, I will have a lot of jury trials come in my diary at 5 o'clock the night before. That is very typical of a career at the bar, whether it's crime or anything. Your clerks are always massaging the diaries for you to cover for other people. And especially in crime, the lists are changing all the time, and they change very last minute. So I've sort of come to terms with the fact that in the not so distant future, I see myself doing a lot of last minute jury trials, and that is fine.
So on being flexible then, obviously the Magistrates Court and Tribunal Service are trying to roll out extended operating hours. How do you see that having an effect? Do you see that having a detrimental effect? What do you think it's a good thing? It's
already in place in Cardiff. I think it's in place in quite a few courts across the country. I've not done one yet. I'm not sure. I think it's still very, very early days about how well they work. To be quite honest, I was against it to begin with. For obvious reasons that I'm not going to go into right now. There are a few people who are doing those sort of trials in Cardiff Crown Court at the moment. They say they're working very well. So there'll be 2 trials. So in 1 week, for example, there will be 2 trials. So there'll be 1 trial in the morning, starting earlier, finishing at lunchtime, court is cleaned. Then the second trial comes in and then they sit later. It seems to be working quite well so far. But I don't have a crystal ball, and I don't really know how it's going to work long term.
Thank you. Joel, if I could turn to you for this one. What major changes do you see coming to criminal law in the not too distant future? As some will know, obviously the sentencing code has come into force today. Do you see that having a big impact?
Yeah, I mean, again, forgive me, a lot of people, I don't know they've studied sentencing yet, but the sentencing code is a brilliant thing. It is basically all the law from, God knows, probably 45 different statutes, all put into one statute, the Sentencing Act of 2020. And it's brilliant. I mean, in my practice as a barrister, sentencing is not normally a problem because they're under acquittal, they get a life sentence, and there's fairly clear guidance on that. But I do sit as a recorder, as a part-time Crown Court judge, and that is fiendish. I mean, I can be sentencing people for 7 different offences, 1 conviction after trial and a few pleas. And it is, until the Sentencing Act 2020, which I was reading, this is how sad I am, I was reading for no particular case this afternoon, and just so pleased with it. I mean, the provisions before, the Court of Appeal Criminal Division spent quite a lot of time having to unpick judges who passed the wrong sentence in the most excusable circumstances, that they misunderstood the interaction of the, I don't know, the Crown Court Sentencing Act 2010 with the Youth Justice Act 1990, and God knows what else. So the sentencing thing is a very good thing. Developments, well, we never really see them coming. I mean, the two big common law, if you will, developments or judge-made developments in the last few years were JOGI on mental element joint enterprise, typically in a murder where there's a big fight and the people who didn't actually kill him, what state of mind did they have to be guilty? And WAYA, W-A-Y-A, which was a case in the Supreme Court. JOGI and WAYA both the Supreme Court. WAYA, a Supreme Court case which brought in ideas of some little known bits of the European Convention on Human Rights into confiscation hearings. And what tends to happen is you have these big unexpected judgments by the Supreme Court, and then the Court of Appeal Criminal Division they fling the doors open, and the Court of Appeal Criminal Division spends the next 3 years nailing them shut. So that's still going on, that process. I really don't know what judge-made law. The sentencing code is brilliant. People who pick up the Sentencing Act and people who start to practice after today, indeed, when it comes into force, will look back at sentencing before and say, what was so difficult about it? Well, trust me, it was horrible. But that's a great leap forward. And why it wasn't done before, I've no idea. And who spent the months tying it all together, I've no idea if they deserve a medal.
Thank you. Just to go back a little bit, re your obviously you've told us about your specialisms. You've got a fairly wide practice in terms of defending for the Solicitors Disciplinary Tribunal and prosecuting for the Bar Standards Board. How did you go about actually developing your practice in those areas, and what advice would you give to any students that were looking to potentially specialise in more niche areas of the law?
I mean, Larry's touched on this already. I think the answer is never say, well, you didn't put these things, never say no. If a solicitor rings you up and says, do you know anything about extradition? And you say, well, when do you want the answer? And they'll say, I've got some papers that, I need, you've got a week. I say, yeah, I know it from soup to nuts, not a problem. I think you need to be willing, you need to do your best in any cases. And of course, there are people, I knew a barrister who did lots of courses on fraud and did get more into fraud. But I mean, terrorism was a massive part of my practice. I went from endless terrorism trials to trial for several years. And that was purely because I had a very close and friendly working relationship with a busy solicitor. We were doing normal crime, if you will, drugs, violence and stuff. And then he started, for various reasons, he suddenly became the flavor of the month amongst the jihadi community. And because I was his, standing brief and we were friends, I started doing that. And the next thing I knew, I was doing that. I said for several years, I did almost nothing but big, long, very serious, very nasty terrorism trials. So I think be flexible, never say no. And, don't ignore the phone call or the email late at night. I think you're allowed these days to say, I'll get back to you in the morning. There are family-friendly rules, which is probably something Larry would have developed if she was talking more about these flaming split trials, but that's another subject. But I think you need to stay flexible. And if people like what you do and you build good working relationships with solicitors, and go where life takes you.
Thank you very much, Joel. Just before I ask the next question, just a point of housekeeping that I've been asked to raise by Nikki. If anybody watching does have any questions that they'd like answering, if you could pop those into the Q&A box at the bottom of your screen as opposed to the chat function, it just makes it a little bit easier for us as presenters to be able to see them, and then we can direct them a little bit later on. So Oliver, from a junior perspective then, what developments do you see coming in the next 5 years, and how will those go on to affect your practice, if at all?
Sorry, I'm on mute. What's been quite interesting recently, in terms of sentencing, I agree wholeheartedly with Joel that the new Sentencing Act is brilliant. And in fact, one of the guys that I went through was doing pupillage at the same time as me was a guy called Lyndon Harris, who's been heavily involved in bringing that sentencing code to fruition and worked previously with the Sentencing Council. He's a very interesting guy when it comes to sentencing and knows probably more about sentencing law than anybody. And it's always been quite interesting whenever I bumped into him and actually heard him speak back in, I think, late 2018 about sentencing and sentencing council issues. But one of the interesting things that's come up in relation to sentencing is the case of Manning this year, which has been cited in pretty much every defence counsel's mitigation subsequently, being that the pandemic is something that any sentencing judge can take into account when it comes to the question of whether to suspend a sentence or not, especially if any defendant has any sort of ill health, because the lockup of 23 and a half hours a day means that custodial sentences are that much more onerous. So that's been quite an interesting development in the last 12 months, and certainly something that's had an impact. One of the things that I think will be quite interesting to witness where it goes is in those cases where delay becomes even more of an issue than it already has been. There's case law already which says that, you know, delay is again something that can be taken into account when it comes to sentencing. But also, I think you will find increasingly that the prosecution will be looking at reviewing cases within its backlog and simply discontinuing a large number. I really wouldn't be surprised if that happened, given the fact that, you know, more and more cases are piling up in the system and they're simply not being dealt with. So that backlog was huge before COVID. It's now enormous, and I think there's in some ways the prosecutors will have to look at it and say, is this really in the public interest? No, bin it, on we go. But the effect of delay, both therefore in terms of sentence, is going to be huge. I had a case that was in a warned list in February for an alleged ABH that dated from April 2018, and that was delayed through it went through its first warned list, didn't come in, put into a warned list in September, heard nothing, so I presume it didn't go ahead then either. It's just been delayed and delayed and delayed, and like many cases, that's happening. But I think the impact not only on sentencing but also on the memory of the witnesses involved and the complainants and the people, the independent witnesses, frankly, however good their statement was that was taken by the police at the time, their memories will fade, things will become hazy, and it's going to have a really interesting impact. Not only that, that's sort of one side of things in relation to the trials, but I think the increasing impact of technology will be seen in the criminal courts. I suspect it will be slow on the uptake, as it has been with many things, but I think the increasing use of scientific evidence, more and more prevalent use of camera phones and that sort of thing. Already it's a huge feature of so many cases, and body-worn video has been a huge development in the way that the police use that. So more and more scientific evidence, video evidence, etc., will become de rigueur in the criminal courts. I think that will be quite interesting in terms of arguments over its admissibility, but also in the impact it has. I wouldn't be surprised in the number of guilty pleas we see. So it is something that it'll be interesting to see where it takes us.
Thank you. Okay, so just before we turn to some questions from the audience watching, Laurie, in a few sentences or less, what is your golden egg? What is the most important thing for anyone looking for pupillage this time around to be doing?
I don't know in terms of pupillage applications, but the one thing that I always tell people, whether it's pupillage fairs or today, and I'm going to sound like a broken record, is keep your options open. as Joel was saying, never say no to that phone call. If someone has an opportunity for you to go and see a bit of this or a bit of that, you need to take every single opportunity that you are given. Unfortunately, when you're in a mixed practice, it's very difficult when you're applying for pupillage not to spread yourself too thinly. I know that's one of the questions in the Q&A section, so maybe I'll just answer that now. The difficulty is you can't say, yes, I want to do crime, yes, I want to do family, because a mixed set chambers isn't going to be looking for that. And you will inevitably have to be very diplomatic and say, yes, I'd like to do this, yes, I would like to also do that. I got asked in my pupillage interview, what about crime? And I gave the same response I've given in this webinar about how I enjoy doing oral advocacy. And I was asked, well, what about family? And my master's dissertation was on end-of-life law, and 30 Park Place is a big court of protection practice. So basically, you just have to be, you have to have your finger on the pulse of everything that is going on in that chambers. From a mixed set point of view, you can't know everything. They don't expect you to know everything, but they do expect you to keep your options open. So that would be sort of my tip for today's webinar. Keep your options open.
Thank you. Oliver, can I ask you the same question? What's your big one?
For me, if you're after a career at the criminal bar in particular, the thing that all the sets will be looking for, and it's come up in this webinar as well, is oral advocacy. That's the key to it, because as Joel said, you will frequently find that the best orators are those at the criminal bar. How do you improve that? How do you make your mark? Well, practice. Advocacy and practicing advocacy doesn't have to always be a question of mooting. It can be anything really. Any sort of parliamentary style debating, giving speeches, persuasive speeches, after dinner speeches, but even it can extend beyond that. It's about persuading people. One of the things that really helped me, and it's going to sound slightly bizarre, is that I had a gap year after school and I worked as a receptionist at a GP surgery. And actually what I did, my day in, day out, was one, acting as a kind of bouncer as a GP surgery, I suppose, and making sure people who were either clearly just sort of bringing the doctors every 5 minutes, or I had to sort of fob them off with, well, you can have a phone call from the doctor and that sort of thing. But really, it was dealing with people who were stressed, who were anxious, who were in pain, and it was a question of persuasion. I can offer you this doctor's appointment, tomorrow, which is, as anybody who knows who tries to ring a doctor and tries to get an appointment, it's very difficult to do. So juggling that, answering however many hundreds of phone calls a day, trying to persuade people, trying to deal with their emotional vulnerabilities, trying to appease them in some way, all that sort of thing can be quite helpful. So advocacy doesn't have to be in court, doing mooting style, formal debating, anything like that. It can be other things, but it is just a question of really finding your voice, practicing speaking in as fluent a manner as possible, and trying to be persuasive, because it is that the criminal sets will be looking for when you're applying for pupillage.
Thank you. And Joel, finally, if we come to you, as someone with a long and distinguished career at the bar, what is your top tip?
For pupillage, you mean? I mean, it depends on the set. I come back really to look what you're being asked. I mean, Doughty Street is a place where you are expected to share the chamber's ethos. Well, look it up, work out what it is, and then think of an answer that addresses it. All chambers are looking for certain qualities, certain things. Look at the website, look at the application form, and address them, because you can have people who are clever and people who are articulate and all the rest, but if they don't answer the question, if there's someone filling in a form, and they may be filling in a form to read, God knows, 200 CVs, they may be filling in a form of some of their interviewing, if inshallah you get through the first phase, but you need to give them a reason to give you the marks for that in that field. So look what you're being asked and address that, and obviously do your best do your best to do it well.
Joel, I have a question in terms of because there's a lot of concern in regards to the lack of earnings because of the reduction in criminal aid. A lot of people have seen it kind of like as a means to discourage them from pursuing a career at the bar. But obviously, you've stayed for a long time. What has kept you going, and what would you say to people that are kind of concerned to the reduction in legal aid?
I don't know if the CBA, the Criminal Bar Association, is monitoring this, but if I'm abducted halfway through, tell the police that's who we suspect. Look, you hear a lot about earnings being very low, and it is true earnings are lower than they were, and it's also true earnings are low compared to some other bits of the bar, at least. And it's also true that some solicitors' firms simply can't make ends meet because for reasons connected with them. But it's always seemed to me, and it still does seem to me, if you are a busy criminal brief, you are probably not immediately, because the payments lag behind the work you do, though it's much quicker than it used to be, but not immediately, but you are probably earning what an awful lot of the population would think is an okay income. If you are busy, if you've been doing it for a year or two. Now look, Lowry and Oliver are far better equipped than me to either shake a fist at me or nod, or probably say no comment in case the CBA is watching them too. But I do think, I think we need to say there's no money in it compared to what? If you, people just, there used to be these dues, criminal bar meetings or meetings of criminal barristers, and people would say, you know, I'll go and do this hearing, I get paid less than a plumber will get. To which the answer is, well, firstly, you know, I've met a couple of barristers who used to be plumbers. I've never met a plumber who used to be a barrister yet, though I suppose is always the first time. And secondly, they will be telling you about a pre-trial hearing where they've had to travel all day, they've got £37.40, but they won't be telling you about the case where they picked up a plea at the last minute and they got many hundreds of pounds for a fairly quick case. So yes, it is not the area of law. If you have the choice between Chancery law and the criminal bar, and you really can do both, and you're interested in making more money, of course go and do Chancery. But don't be too put off, don't be too defeated. If people do well and they are busy, then I still think there is a perfectly acceptable professional living to be made.
So, Oliver, if I can come to you, as someone that didn't study law initially, do you have any advice on actually getting your foot in the legal door, especially at the moment with mini pupillages being sort of few and far between?
Yes, I think one of the things that clearly most or everybody on this, the participants in this webinar have done is join an Inn of Court. It's obviously difficult during COVID because in events are being either conducted virtually, and so you don't get the opportunity to mingle with people and talk to them afterwards, or simply, you know, you can't meet up with people, you can't do court visits in the same way, etc., etc. But if you are somebody who, for example, is going on and studying the GDL, it's a theme that's been running through this, but it's a question of really not saying no, attending as many events as you can, whether that be virtual events like this one, or indeed when hopefully the world has been vaccinated or something similar, attending in person. What helped me, I think, was as soon as I started the GDL, I just spammed as many chambers as I could with mini pupillage applications, and actually ended up during my GDL year, I think I did 5 or maybe even 6 mini pupillages, some of which were week-long minis during my GDL studies. So basically what I did was prioritize doing minis and getting work experience over sometimes attending class, etc. Obviously you have to attend a certain number of classes, and I try and rearrange and all that sort of thing. But occasionally, simply, you simply had to prioritise minis, and it's actually what our course director told us, that if you've got a mini pupillage, go for it, because it's such a difficult opportunity to come by. One of the things that led me, and it's in fact one of the things that led me to do the criminal bar in the first place, was it's a slightly strange connection, but it was my sister's maths teacher's husband was a criminal barrister. And he's in fact now the Judge Advocate General. But I contacted him, sent him a rather cheeky email and just say, could I possibly come and shadow you? And this was way back in 2015. And he wasn't able to do so at the time. I wasn't able to shadow him, but he set me up to do what was called judicial awareness course, basically like marshalling with a judge, with His Honour Judge Horton at Bristol Crown Court. And I sat on the bench with Judge Horton for a week and absolutely loved it. It was fascinating. And really that led me into kind of starting to think about the criminal bar as the place to be. Subsequently, I did my first mini pupillage was in immigration with an immigration barrister, and then did one in a criminal set. Loved it. Did another in a criminal set, another in a criminal set, and it went from there really. And so it is really about, I think, just trying to put in as many applications for minis when you can. I understand at the moment it's impossible, but another thing you could do, and it's something I wanted to mention, which is some of you may work full-time, some of you may work part-time in order to make these, to fund your studies or whatever it may be. But there are opportunities to visit courts. You can go and sit in public galleries, depending, of course, on COVID restrictions, etc. But one of the things you can do in, for example, any magistrate's court is, if you can't get there during the week because you're working full-time, whatever it may be, Saturday morning courts. Go and sit in and watch a few bail applications, a few first appearances, and you just get a flavour of what it's like at the junior criminal bar, because most chambers will have a rota whereby their pupils, their second six and third six pupils, and sometimes junior tenants have to attend courts on Saturday mornings on a rota. I did it all the way through my 18 months of pupillage, attending 2 out of every 3 Saturdays. And you just get a call on a Saturday morning, go to court, pick up 1 or 2 first appearances or overnight remand cases, and go from there. And it can be a really interesting way of seeing what it's like at the junior criminal bar, because it is like a snapshot really of what a normal magistrates court day would be like.
So, Joel, I think you mentioned that you'd sat on pupillage panels as part of Doughty Street Chambers. Somebody who's got, let's say, not the best A-level results, but is predicted highly in their undergraduate degree, have they got a realistic chance of obtaining pupillage, or do they need to be looking elsewhere?
I mean, I would be surprised if any chambers had automatic points awarded for getting. There's a question in the Q&A I've seen, getting DCE or whatever. They are looking for people with a suitably high intellectual capacity. So the answer is, I think, if you did crash and burn in your A-levels, but you think you're going to do really well in your degree, you need to say so, and you need to explain that and address that as part of your application. I don't think it is it's obviously not a great help, but I don't think it's a total bar at all. I think if you can present a case and you can say, look, I don't know, I had family health problems or whatever. So I did very badly in my A-levels, but I've been working very hard. I think I'm on course to get a first. Here's what happened to me. I think most chambers would firstly be interested, and it would get their attention, it's a bit different, and secondly be impressed that you are doing what they are looking for, which is an ability to persuade people of stuff. So I'm nicking what Oliver was saying, really. It's, that's the guts of it. You are persuading people to take a certain view or believe or think it's conceivable a certain thing might have happened. So if you can do that with your bad A-levels, mine were shocking, by the way. You do that, but we had a Labour government before Mrs. Thatcher. So I'm just playing how old I am now. Mine was shocking, but you know, in the end, you get there with luck.
If I could briefly jump in on that as well, Kyle. I'm about to post in the Zoom webinar chat to hopefully to all panelists and attendees. There's a blog post by my co-pupil, Gemma Noble, which actually describes quite a similar situation of not having the best A-level results in the world by her own admission, and that's what the start of her blog there. But she goes on to explain what she did, saying she studied a BA in journalism at a virtually unknown arts university, and then basically details her path to the criminal bar. That was written in June of this year, and she is now doing extremely well, doing quite a lot of Crown Court trials and that sort of thing. So it can be done. Don't be disheartened. Just you've got to, you know, start sort of self-improvement from now, really, I suppose.
Thank you for sharing that, Oliver. I'm sure our attendees will find that most helpful. Laurie, if I can come to you, as somebody who doesn't just deal in criminal, obviously you've mentioned that you've got a family practice as well. What are your tips for handling vulnerable or hostile witnesses, and what skills and qualities are required of an advocate who does that regularly?
So first of all, before you handle vulnerable witnesses, before you do that in the criminal court or in the family court, you should have done your vulnerable witness training. So I've done the family court vulnerable witnesses training, which is relatively new. I've not done the criminal one yet. They're very similar though. So it's very hard for me to add anything to that because it is really detailed. There is so much that you have to take into consideration. It's not really something that you would be expected to know beforehand. You just have to be aware that there are these issues about vulnerable witnesses. But it's so particular in terms of how you are supposed to deal with ground rules hearings and how you cope with vulnerable witnesses. I can't really give any general tips, unfortunately, because it's so regulated, understandably so. If you are interested in vulnerable witnesses and you think, oh, this is, you know, maybe you're going to do a master's dissertation on it, I don't know. Section 28 is something that's coming in quite a few courts. It's being brought in South Wales relatively recently. I know someone who's done one trial on it in the Swansea Crown Court so far. So Section 20, I can't remember the section, Youth and Criminal Justice or something like that. Section 28, Youth Justice and Criminal Evidence Act 1999. That's what Section 28 is. So that is the pre-recording of vulnerable witnesses' evidence. So then in a Crown Court trial, it's just you just press play and that's the witnesses' evidence done. So if you are interested in vulnerable witnesses and that's something that you'd like to research more fully, have a look at Section 28 and maybe you can discuss that in your pupillage interview and how you think that is going to affect the interests of justice. I don't know.
Thank you, Laurie. I think there are a lot of questions in regards to in terms of knowing the right chamber for you. There's a question directly at you actually in terms of what makes your chamber stand out, like, because she's thinking about applying to 30 Park Place. So what do you look for in a chamber to know that, okay, this is for me? I know some people actually look at whether some chambers allow their barristers to kind of do a lot of mixed practice, you know, while some, because they are specialists. So what do you think will make a chamber stand out to you?
Well, every chamber's is different. When you come to filling in your pupillage application forms, you will become very acutely aware of this. Do not have a blanket approach to all of your pupillage application forms, whatever you do. I know Oliver touched on this earlier. You have to make sure that it really is tailor-made. There's so much to take into consideration with chambers. I wouldn't narrow your options. You probably will have a favourite. Mini pupillages. It's a sensitive issue with everything going on in COVID-19. That's the best way to get a feel for a chambers. I did quite a lot of mini pupillages and I wanted to do a variety. So I did a lot of different areas of law, and I did a lot of different locations. I did multiple in Swansea, Cardiff, Plymouth, Exeter, and London. I went to university in Exeter, by the way, so that's the connection to the southwest. That's the best way to try them and find out if it's for you, because what they put on their website probably isn't an accurate reflection of what life is like in that chambers. You will have multiple mini pupillages where you get left in robing rooms, you get forgotten about, and I had some terrible mini pupillages, and I ended up not applying into those chambers because I was so horrified. 30 Park Place was not one of them, for the record. So definitely do mini pupillages and get a feel for them. In terms of why I chose 30 Park Place, in my opinion, 30 Park Place had a really good reputation, particularly in South Wales. It really stood out from the rest. It has a really mixed practice. That was something that I wanted to do. And there was just so many options as to where you could specialise and what sort of work you could be doing in the future. And as I said, I had sort of done a bit of clinical negligence. I touched on end of life law. I was interested in criminal law. It was the best place for me, and that's why it was my favourite chambers. But it might, you know, you need to keep your options open and apply to a few different places. But I really enjoyed my mini pupillage at 30, and I really enjoyed pupillage at 30. And yeah, it was the variety of work. Hopefully, if you do a mini pupillage, you can see quite a lot of that. And if you do go for an interview somewhere, have a look at some interesting cases that they've been involved in. That was something that sort of caught my eye about 30 Park Place. We're involved in quite a lot of high profile sort of Welsh cases, so like the infected blood inquiry, or there was a big case earlier on in 2020. It was a judicial review case about the use of the Welsh language and how Welsh language statutes has the same weight attached to it as the English version language of the statute. So have a look at some interesting news articles, think, oh, where's that barrister from, and go down that route. If you are interested in Welsh things, of course, then you are inevitably going to be drawn to somewhere like 30 Park Place.
Thank you, Laurie. I have a final question for Joel. If you can just leave us with a final word of advice, I think that would be useful to everyone.
Dress cleanly, pronounce harassment as it should be pronounced. Read the website, as Laurie's just said. If this Chambers has a case they are keen on, they will be boasting about it. They have publicity. Read it, know it, and touch upon it, because either there will be a barrister on the interviewing panel whose case it is, or at least the others will be repressed, even if they realise it's completely transparent and you don't give a monkey's about, for example, the value of Welsh language in interpreting statutes, Larry. I'm sure everyone does. But even if you don't give a monkey's, they'll still be impressed that you've done the work and you've prepared properly.
Oliver?
Really, for me, it's a bit of a rallying cry. Go for it. Go for it at the criminal bar. It really is a fascinating, varied, and it really just engages so much of the human experience in a single career. Somebody's asked if there's time for work and play. I saw a question. Yes, there is. Yes, you can have a life as well as the criminal bar. But of course, it's going to take up quite a lot of your time. But it really is a fascinating career. Don't be put off. Do go for it. And my last piece of advice is speak slowly. You can never speak too slowly in a court of law.
Thank you so much. Thank you to everyone for taking time out of your busy schedules to be here. We're really, really grateful, and we wish to kind of do something similar over the years in the next future, hopefully. You all have been really, really brilliant, so thank you so much. Unless there's any further questions, I think that's about it. I don't know, Kyle?
Nothing else from me, just to say thank you to everybody for coming. Thank you to our panelists who've given up their time this evening. And of course, thank you to the education departments that have helped to put this on. We do have 2 further events. So for those of you that are AGIS members, you know, please keep your eyes out for your emails. We've got another one coming up in public, and we've got another one coming up in, I think it's commercial law as well. So they're coming up in the not too distant future. So if you're interested, please do attend.